Bismillahirrahmanirrahim. So this is one of the most long-awaited discussions about the replacement of the old statute, the Arbitration Act for Pakistan in 1940, which is heavily outdated as it was based on colonial era legislation inherited from pre-partition times. 75 years after the partition, we still stand at still while the rest of the world has taken gigantic steps. New arbitration practices, procedures, and principles have emerged globally with a focus on the efficiency, fairness, and enforceability of arbitration awards, whereas the Arbitration Act 1940 is deficient of these developments and advancements that best reflect the world's needs. The 1940 Act not only depicts a narrow focus covering limited type of arbitration on particular industries. If Pakistan aims to stand on par with the rest of the world, we need to accommodate a wider range of conflicts, and we require a more comprehensive arbitration structure. By replacing 1940 Act with more modern and comprehensive legislation, Pakistan sought to improve its arbitration framework, enhance its reputation as a reliable arbitration jurisdiction, and foster economic growth through increased domestic and international dispute resolution. And we don't have to invent the wheel for this. In fact, we are so too late in adopting the alternatives to court legislation that even the neighboring countries like India brought the first updated version of 1940 Act in 1996. After the inauguration of the Chartered Institute of Arbitrators Pakistan branch last year, we realized the importance of a Domestic Arbitration Act. Further, model laws such as the UNCITRAL model law on the international commercial arbitration are recognized and accepted globally. Moving towards a Domestic Arbitration Act that is model law compliant not only enhances country's reputation, but also promotes consistency in arbitration practices, making it convenient for international parties to engage in arbitration proceedings within that jurisdiction. We have proposed 3 different pieces of legislation for Pakistan: a separate International Arbitration Act, a separate Domestic Arbitration Act, and a Conciliation and Mediation Act.